Code enforcement? Okay, and I will call us to order. First order of business is rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. McCullough, I'm guessing you probably don't expect to have to call any witnesses today?
No, this is just for the purpose of the motion.
Yes, sir. And you're here on the request on IFTPAR, correct? Which case are you here on, sir? If you would you might not have any testimony to give either, but if you'll go ahead and stand up and I'll swear you in. Do you all swear from the testimony you give us the truth, the whole truth, and nothing but the truth? Thank you. And I think everybody has been here before, so I'll do an abbreviated introduction. My name is Drew Smith. I'm the Code Enforcement Special Magistrate. I am not an employee of the city. I am here as an independent trier of fact. It is my role to hear the evidence and then enter an order when that is done. As you've all been here before, you will hear me express that order verbally today, and it will be followed in the mail by a written order. With that, in the interest of Mr. Holmes and his attorney's fees, I'm going to ask if you're ready, then we'll go ahead and proceed with the Holmes case. You don't have to read it. It's as long as you have it clear on the record. I know which one I'm talking about, and they know which one I'm talking about. I've reviewed the motion, and actually my first question, unless you have anything you want me to hear, I'd like to ask the city a question. Do you have any objection to a stay given what's going on here?
We do.
Okay,
Explain that.
then I'll let you express your motion, and then I'll let the city express their objection.
Thank you. And your honors had exhibited a tremendous recall of the complex facts of these procedural aspects of this case. Just briefly, in summation, in May of last year, this tribunal found Mr. Holmes in violation of the pavement parking requirement for parking wrapped trucks on a grass strip, and that was appealed. And then there was an amendment to the building code to address directly Mr. Holmes' situation where trucks would be parked on a grass strip, recognizing, I think, that the paved parking statute didn't deal with it directly, but only by implication. And he was given a notice of violation for the new amendment, and the new amendment said you couldn't, use trucks for advertisement unless they were in the regular course of business. This court basically found that he wasn't using it in the regular course of business, and therefore he would be in violation as well of the new ordinance. Well, Mr. Holmes has taken that up on appeal, as well as sought an injunction of the statute and the enforcement of the statute by the city of St. Cloud. So we have two pending appeals, and we have a circuit court proceeding, and they all address basically these two orders, which really address the same factual circumstances involving Mr. Holmes' wrapped vehicles. So we're asking for a stay, and I'm sure the court will remember that the court had gone to the extraordinary, taken extraordinary action in delaying enforcement up until January 30th of this year.
And I know I suggested this option too, is that if you couldn't get heard in by that time to come back and we would consider it further. So yes, I
That's right. And
do recall my own order.
Your Honor recognized that these are important matters before us, and they're not matters that are usually decided by a special magistrate. And so we're coming back to ask that pending a final decision.
And where are you procedurally in the injunctive relief? Let me ask specifically about that one first. Where are you procedurally in the injunctive relief? And do you have a critical path or any idea where your path is with hearing time and getting it?
And the answer is no. And the reason for that, we were in front of Judge Schreiber. I was working with Judge Schreiber's judicial assistant, trying to get a hearing time. Under her criterion, it was not considered an emergency situation. So in respect of her criterion for emergency situations, we hadn't put it on an emergency document, but we were trying to get it expedited. And then we got a brand-new judge.
Reassignment.
Yeah, so it's been reassigned to that judge. We've been talking to that judge's judicial assistant. He's new. The judicial assistant is newly assigned. They're basically getting a whole raft of excess cases that other judges were sending, and I get a sense that there's some confusion on their part. So I cannot predict when we're actually going to get in front of a judge. We're on the injunction motion, so, but I'm hopeful that it would be soon. We're pressing for it, but of course we can't force the court to do anything.
And then on the appeal, where is that in the process?
Okay, so it's been fully briefed on the first appeal. The brief in the second appeal will be due within the next 15, 20 days. We're prepared to submit that probably in the next day or two. So both appeals will be fully briefed by the appellant, and then the city will file their response brief, and then there would be a possibility of a rebuttal brief on our part, but then they would make a decision. And the way that that's working is it's totally out of our control, because we're following these things with the circuit court. The circuit court's appointed a panel of 3 judges, and apparently they have to get together. However, the only decisions that have been made are in our request to amend the record and to amend the briefs and to do things like that, and also motions that the city had filed, and it was decided by a 4th judge.
So that's both appeals have been assigned to that 3-judge panel?
No.
Or to a 3-judge
No,
panel?
the first appeal has been assigned to the 3-judge panel. The second appeal has not been assigned to any panel yet. We've requested that it get assigned to the first panel out of judicial economy, and we've requested consolidation. We haven't heard anything back on that motion. And we've been told it is uncustomary for us to get oral argument or to ask them to do anything until they're ready to do it.
Okay. Understood.
And I'm being gentle. I mean,
Understood.
we were told by a judicial assistant for what we thought was the head judge of the panel, leave them alone. So that's where we're at. And it's a very important freedom of expression situation. There's no way that that the town is going to be harmed. They're going, if they're right, they're going to get their money. But if they're wrong, and you enforce this and start the clock running and the sanctions tolling against my client, he's going to have to make a decision to do without, expression. And so we think that to maintain the status quo, which is the main purpose of a stay and one of the main purposes of judicial deliberation, would be a desirable situation in this case. Thank you very much.
Yes, sir. City?
Counsel. The city objects to this motion, and I'm going to give you just a little bit of support as to why that is. It's a little bit out of character for the city. But with regard to the Grass case, as I'll refer to it, the original case that was initially up on appeal and is still up on appeal, that case substantively is in compliance. It's on appeal, but that's been complied with. This particular case, which was heard by you back in the middle of November, the property is still in noncompliance. There's been partial compliance met during the ongoing proceedings, but there remain 2 box trucks in front of the property that are still in violation of the code section that was at issue before you that you found in violation. The remedy to bring the property into compliance, as I understand from conferring with code enforcement, would be to, without any cost to the respondent, move the box trucks, 2 of which are still in violation, as a 3rd box truck has been brought into compliance by repositioning it to the rear of the property. That could be done, I would submit to you, within a matter of hours, if not minutes, to bring the property into compliance. Secondly, no brief has been filed with regard to this case. A notice of appeal was filed, but no brief's been filed.
And that's consistent with what was,
And
that was what was
correct,
told to me.
but I point out to you that there would be no financial impact on the property being brought into compliance while we await the development with regard to the appeals themselves. I will point out just historically, the initial brief on the prior case was was stricken. An amended brief was only filed last week on that case. The injunction case, our office filed a motion to dismiss. That is being set for hearing after meeting of council to set our motion to dismiss on the injunction before the appropriate tribunal. The point being, the city, in part, wants the fines to begin to accrue to incentivize the respondent to bring the property into compliance or to move the appellate process along. There's been no action on this particular matter absent a filing of a notice of appeal on that, and the property remains in violation and could easily be complied with. And so, further, if in fact, I think it's presumptuous, the city certainly feels it's presumptuous to assume that there will be success from the respondent's perspective on appeal. They have that possibility, certainly, but the city feels well-positioned. Your ruling, we feel, was well-reasoned and well-supported by law. And in the event that the appeal results in an alteration of what is currently the status of this matter, obviously the city then will simply have any fines that accrued be rescinded and those will be wiped out, understandably. But we want the fine to begin to accrue. It would only begin to accrue as of February the 1st. And so we're at the 15th now. So it's only a couple weeks in to the period. You gave ample time within which for the property to be brought into compliance. And even while it's on appeal, the respondent could mitigate the situation simply by moving the vehicles that are at issue. There's ample signage in front of that business right now, separate and apart from the vehicles and the signage that is additional and in violation of code. And so for all those reasons, the city sees no reason why the fines per the magistrate's order could not begin to accrue to keep the incentive moving forward and to get compliance. Again, the city is seeking compliance. There was a concern in the underlying case, and I'm sure as part of this appellate process that there's some type of selective enforcement. Code enforcement has presented the city, me, with a list of cases during and since the hearing in November where respondents have been notified of violation and have come into compliance. This particular respondent continues to object to the enforcement of this code, which is his right, but the city is seeking enforcement of the code for all individuals and businesses and seeks that the proceedings go forward as consistent with your order of November 30th. Thank you.
I will give an opportunity for response if there's one requested, but before we get there, I'm going to go ahead and, like I've done in previous hearings, let you both know where I'm seeing this. I'm, first off, to the city, you don't have to convince me that I had a well-reasoned order, or that you think you're going to win. I entered the order that I think was right, so you don't have to convince me of that. But at the same time, and what I alluded to at the last hearing, is I also respect the right of, in this case, an appellate court to come in and disagree with me. I don't think they should, but that is how the system works. Where I do take a little bit of issue with the city's argument is to say that it's cost-free for the respondent to comply with my order. To the extent, and it is the respondent's main point, that this is a First Amendment right, there's a cost involved in that. It might not be a financial one. It may be a financial one. And actually, part of why I think where my head is at, it is also respecting the position of the parties, including the city, is that I'm sure at the end of the day, if court says, nope, magistrate was wrong, city, you got to let him do what he wants to do, I'd be willing to bet that respondent and his attorney can find some financial impact. And so there's a little bit of protecting the city and where I'm leaning right now. At the same time, to the respondent, I'm not willing to just leave this open-ended. So I am inclined to grant a temporary stay to give more time for the court's processes to work through. No expectation that you will be through with appeals by the time that the time I'm going to give, that I think I'm going to give today, runs. But it at least lets you get that. And get in front of a judge on your injunctive relief. I think my leaning is 90 days, a 90-day stay. And again, leaving open the possibility, come back, brief me, where are we in the process, because I want to stay. I don't want to grant a stay that ends up in just nothing happening on this property. And delay tactics, not that you would, but some respondents would. Or same with the city. If either party is delaying, I want to know about that, because this needs to be resolved in the interest of everybody. So my leaning is 90-day stay of enforcement of my order, so no fines are running during that 90 days. I would want to go ahead and let's plan on putting it on that agenda for whatever is 90 days out, so that would be May? Are we counting that right? Go ahead.
For
Yes, go ahead.
clarification, 90 days would run through the end of April. The original order said compliance by the end of January.
Okay.
So is that right? Just for just asking if that's
So that
the,
May hearing would be our hearing.
May
And that's why I was trying for the clerk to schedule it for a hearing for a status update. We'll just call it status update, and then I would hear if there was a need for an additional extension. Part of my thinking right now, too, is if I give you an open-ended stay, your request for injunctive relief, probably they win on their motion to dismiss because they're going to point out to the judge it's moot. And I don't know if a judge will rule. They might say that anyway. They might say, not my business. But I'd at least like the judicial system to have their say, to have an opportunity to have their say, just as I said last time. I want to respect that. So does anybody have a reason that you would like to convince me either to go to an open-ended or give more time, or that I'm just wrong? I'm getting a head shake from the city. Your client has something he'd like to say.
That sounds condigned to us, Your
Mr. Holmes raised his hand, so I don't know if there's some communication he needs to have with you before I formalize that.
Yeah, I wanna mention something on the last hearing. I mentioned big chains like Home Depot, Pinch a Penny, Rent-A-Center. My question is, and you mentioned.
I'm not going to hear any evidence, and I'm not going to answer any questions, so
Oh,
I'm
okay.
just talking about my ruling.
Okay, no problem.
Okay.
Thank you.
So it would be May 17th.
The clerk has written down May 17th will be the date of that hearing. There will be notices sent out to the respondent, though, correct? Yes? Yes, and you will also receive notice.
Thank you, Your Honor.
Yes, sir.
Thank you.
just so a 90-day stay, which will, I guess that'll be, April 2nd.
Well, let's go ahead and
something like
run that stay through May 17th,
that. Through the date of the hearing.
to the date of the hearing.
Okay, thank you, sir.
And then we'll decide, we'll figure out where we are at that point. Okay?
Thank you.
Since, I'm sorry, sir, you're fine. What was your name, sir? I'm sorry. Paul Chisholm. Since Mr. Chisholm is here, can we go ahead and hear his case too? He didn't have to wait around. If he doesn't choose to, you're always welcome to. And this is a respondent request. This is case, I'll go ahead and call it. Case number 2022-1989, IFT PAR Holdings LLC, 522 New York Avenue, St. Cloud, Florida. Violation of St. Cloud Land Development Code, Section 3.3.1F, and others. And sir, this is, I think, your request, if you'd like to approach the podium and let me know what you are requesting of me today.
I'm just requesting time to fix the place because the tenant decided that we are not going to get into the house. They refused for us to go into the house, and so they leave at the end of February. So I'm requesting until at least the end of March to bring it up to code.
Okay, and so you're saying the tenant is not allowing you in to do the repairs that I've ordered you to perform?
Right, yeah.
Any response to that from the city?
I can confirm that is true. I did call, when Paul.
Name and title for the record, please, just
Oh,
for
I'm
the
sorry.
record. That's okay.
April Bennett, City of St. Cloud Code Enforcement. I did talk to the tenant, Fallon. She did state that, yes, she is not allowing them to enter the home. She had some appointments set with them, and I guess there were no-shows, and she works at night, so she doesn't want people in the home with her children, so she's not going to grant him access.
Okay, well, makes it hard for him to do what I've asked him to do if
Correct.
she's not letting him into the property. And I'm sorry, the request was for, she leaves when again? I'm sorry. End of February. End of February, and you asked for the end of March? Just in case there's any delays on either end, Ms. Bennett, Officer Bennett, what do you think of, let's say, split, maybe give them another 15 days, make it tax day, April 15th? Do you have any problem with that?
No, that's fine.
So, sir, do you think April 15th will give you enough time once the tenant is gone? And if there are any issues there, if she holds over or something else, and for whatever reason there's a delay, let the code enforcement officer know. And if you need to, reschedule, and I can amend that order, because, yeah, if she's not letting him in, it makes it really hard for him to do
Right.
the work.
Okay.
And if there's a tenant dispute, I certainly recognize the challenges that can create. so I will enter an order extending your compliance date to April 15th, sir. Thank you. Now we're back on the regular agenda.
Case number 2022-278, Gatfield Williams, owner, location of violation 1202 Wisconsin Avenue, St. Cloud, Florida.
Alex Miller, Code Enforcement Officer for the City of St. Cloud. I would like to null pros this case. Thank you.
Case number 2022-992, Susan L. Prime Wilcom, RLE, owner, location of violation 316 Delaware Avenue, St. Cloud, Florida.
Good afternoon, Melissa Howes, Community Compliance Supervisor. This is going to take a little while for these girls to get used to not being code enforcement officers. We're community compliance officers. It's actually going to take me a little while,
Is
too.
that official today? I mean, that
It is
I know
definitely
you mentioned it last
official.
time.
It is definitely
I'll make
official.
a note to, tell me again, what is the new title?
Community Compliance Division. So they're community compliance
Compliance
officers. Yes, sir.
Thank you.
Okay, at this time, I'd like to enter into evidence the following items: a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, a copy of the notice of violation sent by regular mail posted on the property and City Hall, a copy of the statement of violation and notice of hearing sent by certified mail, a copy of the statement of violation and notice of hearing sent by regular mail to the owner posted on the property and City Hall, a copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $273.78, and the respondent is not here.
Thank you.
This is going to go back a little ways, so bear with me. On June 21st, 2022, I received a complaint from the next-door neighbor stating the conditions of the rear yard of this property was horrible. He gave me permission to walk on his yard to take photos of all the violations. He stated that the landscaping was all overgrown and there was a dead tree that was on the ground that had been there for several years after a hurricane. Officer Bennett and I went to his property and verified the landscaping being overgrown, the dead tree on the ground, high grass, the exterior property areas in need of being cleaned up, and the screen enclosure having missing screens. 8 photos were taken. That's the screens missing. That's the tree debris. That's the tree from the neighbor's yard.
Is that pool secure?
Yes, there's a chain link fence around it. On June 22nd, I reached out to the tenant by telephone and advised her of the violations I received. She stated when she moved into the property, it looked like this, and the owner was supposed to have it cleaned up. She stated she was working on the pool water and getting it cleaned up. I asked her if I could meet with her at the property or get permission to walk in the backyard to advise her exactly what needed to be completed. She stated that she works, but I could go into the backyard so she knows what needed to come into compliance. She also stated that some of the items the owner is going to be responsible for because she would do what she could. On June 24th, Officer Bennett and I went back to this property and walked the backyard. The grass was high, dead tree branches on the ground, and the tree next to the fence, vegetation growing out of the gutters. There was vegetation growing on a low-lying cable wire, pool screens missing, pool furniture that had been lying in the ground for some time that needed to be cleaned up, and exposed electrical wiring on the pool pump equipment. 11 photos were taken. So that was going into the backyard through the chain link fence. That's just some tree debris. That is actually the vegetation growing on the cable wire that's running from the house to the rear of the yard. The pool water looked better, but that did show the screens missing. I don't know if you've seen that.
I saw in the earlier photo the
Okay.
screen was missing.
That's the pool furniture that's just laying on the ground. And that is the pool pump equipment, and I took a closer up there to show you that there's exposed wiring. Even the screen door was down. And that's just the other side of the yard. There's the vegetation growing out of the gutters. On June 29th, I sent out a notice of violations by regular mail to the owner of record and the tenant to correct the violations. On July 7th, I received a call from the owner's daughter stating her mom lives with her due to her husband passing. They live out of state, and she asked that I send her the photos by email on what needed to be completed, which I did. On July 11th, I went back to the property to check for progress of work being performed because the owner's daughter had called me saying that the tenant was working on the property. Upon inspecting the property, I noticed that the vegetation in the gutters had been cleaned out. Some of the landscaping had been trimmed due to there being piles laying on the ground, and the vegetation on the cable line was also down. 3 photos were taken. So that shows the vegetation was removed and the debris was, or the landscaping was trimmed. There's piles of debris on the ground there and there. I contacted the owner's daughter that same day to advise her what had been completed and that I would extend the time until July 25th and check for more progress. On July 27th, a reinspection was performed and there were still piles of tree debris on the ground. I also noticed that the pool water was starting to turn green now. 3 photos were taken. On July 29th, I sent out notice of violations by certified mail to the owner of record and the tenant. On August 25th, I checked the status of the property, and there appeared to be only 1 pile of debris on the ground. The pool furniture had been cleaned up and removed. The pool water was still green, the screens were still missing, and the large tree was still lying on the ground, and I have not been able to inspect the electrical wires for compliance. 4 photos were taken. I contacted the owner's daughter and advised since I had seen more improvement and she was trying to find someone to remove the tree because of the cost, I would extend it another 30 days. On September the 20th, a reinspection was performed and the grass had been cut. The pool enclosure had been worked on but not completed. There was still debris on the ground. The landscaping was not trimmed. The tree was still on the ground. The pool water was not clear, and I still needed to verify compliance of the electrical wiring. 10 photos were taken. That's from the neighbor's side.
What was I looking at in that photograph? That last
So I'm in the neighbor's yard. Her yard is the chain link. So all of that landscaping that's hers is going over
I
onto
got it.
his
No, I
property.
see. I understand.
Tree's still there. It's a big tree, too. It's not a little tree. And then that I tried to zoom into the pool equipment, but I couldn't see it. On September 23rd, I reached out to the owner's daughter and left a message to call me. On September 28th, she contacted me back and stated she was doing the best that she could and couldn't find anyone to work, and that she was out of state and the funds were very limited. I explained that if I see the progress, then I would continue the case. However, the pool water needed to be cleaned up. On November 3rd, I checked the property and no progress was made.
What's the status of it today?
Today, it is in compliance.
I thought that's where you were headed with everything. You have established that there was a violation.
Okay,
did
would you
not
want me to
cure it.
just forward
Well,
on?
I'm going to ask you, but you've convinced me there was a violation and that they did not cure it within the time you set in your notice of
Okay.
violation. So you don't have to give me testimony about every inspection.
Okay,
If they're in compliance now.
Okay.
So you can go to, yes.
okay,
You've
so
convinced
I'll
me there
go
was a violation.
to, this was on the 3rd. On the 8th, I ended up having to post the property, did an affidavit of posting and took a photo. That was with the notice of violation. I re-inspected on the 8th. Oh, you want to go right to the recommendation?
That's whatever, you've convinced
Okay,
me there
if
was a
you see
violation.
that
and you've told me that they're in compliance now, so.
Okay,
You've
good
made the
deal.
record with what I think you have to make the record
All
with.
right. We're going to go right through here then. So it's the city's recommendation that the respondent be found in violation of having an accumulation of tree debris, exposed electrical wiring on the pool pump equipment, not maintaining the exterior property areas, including the maintenance of the screen enclosure and in-ground swimming pool, and the pool water not being maintained in a clean and sanitary condition. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $273.78 be paid within 7 days of the written order.
Thank you. And based on the evidence testimony received, I will enter that order, find the respondent was in violation as stated in the notice of violation and as testified to by the code enforcement officer. Find that those violations were not cured by the time required in the notice of violation, but they were cured subsequent to that notice and after, or before today's hearing, and will order the respondent to pay the administrative costs incurred by the city in the amount of $273.78, which will be due within 7 days of the date of my written order.
Thank you, sir.
Case number 2022-1769, Constance Loan, owner, location of violation, 1715 West Acres Drive, St. Cloud, Florida.
Melissa Howes. At this time, I would like to enter into evidence a copy of the courtesy notice of violation sent by regular mail, a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, copy of the notice of violation sent by regular mail posted on the property in City Hall, copy of the statement of violation and notice of hearing sent by certified mail to the owner, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $194.14. And the respondent is not here.
Thank you.
On September 26, 2022, during routine patrol, I observed an above-ground swimming pool at this location and no permit on file. On September 27th, I issued a courtesy notice of violation by regular mail to the owner of record to correct within 10 working days. On October 17th, I checked the permit records. No permit was on file. I sent out a notice of violation by regular mail to the owner. On November 7th, there was no permit on file. I went to the property and verified the pool was still up. I sent out notice of violations by certified mail and took 3 photos. On November 23rd, there was no permit on file. I could not locate the certified mailing card, so another notice of violation was sent out by certified mail, and 1 photo was taken. On December 19th, there was still no permit on record. I took 3 more photos showing the pool was still there. On December 20th, I sent out another notice of violation by regular mail, posted the property and City Hall due to the owner not signing. Did an affidavit of posting and took 1 photo of the posting. While posting the property, the owner's daughter came out and got her mom on the phone, who is the owner of the property. I explained what she needed to do to obtain a permit, and 1 photo was taken of the posting. On January 10th, 2023, no permit was even applied for. 1 photo was taken. On January 13th, I sent out a statement of violation and notice of hearing by certified mail to the owner, which was left with an individual at the residence on January 14th. On January 30th, 2023, I reached out to the owner of the property by telephone to make sure she received the statement of violation and notice of hearing, which she explained she did and explained that she had submitted for a permit. I verified a permit was applied for on January the 30th. I explained to her that it would be great if she obtained the permit by the time of the magistrate. She stated she would not be able to attend due to working full-time. I explained that she would receive another certified mailing with the magistrate's findings. On February 13th, 2023, I checked, and again today, I checked, and the permit has been approved but not obtained.
So all they have to do is come in and
All they gotta do is come in and
pick up.
pay. So it is the city's recommendation that the respondent be found in violation of installing an above-ground swimming pool prior to obtaining a permit by the time specified. The city would like to give the respondent until March the 2nd, 2023 to correct the violation or pay a fine in the amount of $100 a day until compliance is met. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $194.14 be paid within 7 days of the written order by the special magistrate.
Okay. Based on the evidence testimony received, I will find in favor of the city, find that the respondent is in violation for installing an above-ground pool without proper permits, allow the respondent until March 2nd, 2023 to obtain the permit, which at this point just means coming in and paying for it and picking it up. And if they do not do so, a fine in the amount of $100 per day will run until compliance is met. We'll also order the respondent to pay the administrative costs in the amount of $194.14, which amount will be due within 7 days from the date of my order, written order.
Thank you, sir.
Thank you.
Case number 2022-1949, David D. Henderson, owner, Alicia E. Young Henderson, owner, Kara A. Eddy, owner, location of violation, 824 Montana Avenue, St. Cloud, Florida.
Last one for me. At this time, I would like to enter into evidence the following items: a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, a copy of the statement of violation and notice of hearing sent by certified mail, a copy of the PowerPoint presentation, evidence of mailings, the code sections in violation of, a copy of the deed to the property, and a copy of the costs incurred if the magistrate finds the respondent in violation in the amount of $236.78, and the respondent is not here.
Thank you.
On November 14th, 2022, during routine patrol, I observed a wood fence that was in need of being repaired. There were panels down, lying on the ground, exposing the in-ground swimming pool with no barrier around it. The pool was not being maintained, and I also observed a black car in the side yard with no current registration tag attached to it. 6 photos were taken showing the violations. So that's the pool. The fence is lying on the ground right in front of, on the very bottom of that. You can see it better there.
So you're outside of the property taking these?
I'm on the street taking that, yeah. It's a corner lot, so the backyard is on the side, you know, on the street, and the doggies come out to visit me.
Are they tethered? Just loose?
Yeah. That is the car. They kind of backed it into the bushes, but I can clearly see there was no tag on it, and it had not moved in quite some time.
Is that tire flat?
Yes. On November 16th, I sent out a notice of violation to the owner of record and the address in violation by regular mail. On November 23rd, a re-inspection was performed and all the violations still existed. 5 photos were taken. There's the no tag on the car. That's actually where the car's parked, but I can zoom in. There's the fence. I can still see the pool's not being maintained.
But it looks like the panel has at least been leaned back up. Am I looking at these right?
Yeah, I don't know if I got any of it, the
But
fence.
the panel's no longer, there's no longer a
There.
whole section of
Oh.
panel that's down, is there?
No, but,
I don't think they fixed it.
right,
I'm not
correct.
saying they fixed it.
The panel itself, yes, was picked up.
How exposed that pool is a concern to me. That's why I was
Right.
interested in that.
Yes, okay. On December the 5th, I checked the property and someone attempted to put the fence back up, but it was still not up to code. The abandoned vehicle and pool water was still in violation. 10 photos were taken. So we still have like pretty good sized gaps. I could still see that the pool water was green just from, and then there were more slats that just started falling down, if you can see them on the ground. The way they tried to fix it just was not up to code. In the car with no tag. And still. It's hard to take pictures of the flat tires when the grass is a little bit high. On December the 6th, I sent out notice of violations for the certified mail to the owner and the address in violation. On December 22nd, I went by the property and took 4 photos showing non-compliance. I had more slats down, the pool water, the car. The certified mailing was signed for by the owner on December the 20th, so I checked the property on January the 4th. 5 photos were taken showing non-compliance. On January the 9th, I sent out a statement of violation and notice of hearing by certified mail to the owner of record and the address in violation. On January 13th, I received a call from Raymond, who resides at the residence. He stated that he was a truck driver and not there a lot, but his brother lived there as well and is supposed to be taking care of the property. He stated that he would get all the violations fixed as soon as he got back from his run. I explained that the property was going to be presented to the special magistrate on February 15th, and he stated he understood.
So they're the occupants, but they're not the owners. They're tenants?
Well, what he explained to me is it's a family-owned property. So the actual people that were getting notified by, in the property appraiser's address is up north, but they are family-related, so there's like 4 names on the property or something.
And there's 4 that's why I was curious, but so
He said he's related to the family.
related, but maybe not owner.
Maybe, yeah.
Okay. That's why I was trying to get it, see if there's any, if you had any better understanding than I.
No, I didn't really ask, other than that's what he told me.
And of the named owners, have you heard from any of them? The ones that
No,
named respondents?
not one, and they've signed for their certifieds. On January the 30th, a reinspection was performed. It's kind of hard to zoom in to see the pool at this point, but the tag is still not on the vehicle. On February the 13th, 2023, I checked the property, and there were fence slats leaning up against the fence, but they were not attached to it. I zoomed in with my camera, and it appears as though the pool pump is running. In the very back of that photo, I see where it's like bubbling up, like almost a water fountain. I could see it, and I could hear it running on the pool, although I could not verify that the water was clean and sanitary. The black car was moved back approximately 2 feet from the original location, but there was no tag on it. I took 5 photos.
They put air in the tire.
Yeah. Later that afternoon, I received a call from Donovan, who is Raymond's brother. He stated that all the violations had been corrected and he wanted an inspection. I explained that I was at the property several hours ago and that the violations were not corrected and that I needed to do an inspection of the pool water. He stated that he nailed the fence slats up. He put the tag in the front window of the vehicle, and I explained to him that the vehicle needed to be operable as well and that he had only moved it approximately 2 feet, and the vehicle needs to be moved per city code every 7 days. He stated that he didn't want to move it for me, but I told him I had to see it move while I was there. But anyway, we scheduled a time to set up the next day on February 14th at 10 o'clock. So on February 14th, I met, upon meeting with Donovan at the property, the car was being towed away by a tow truck. And so the vehicle is now gone. The pool water was verified to be clean and clear. However, the fence, I do not believe, is still structurally affixed to the post. I explained to him what needed to be done to bring the property into compliance. I also explained that I would be recommending time to comply on the fence to the magistrate before any daily fines would run. It is the city's recommendation that the respondent be found in violation of having an abandoned vehicle, not maintaining the pool water in a clean sanitary condition, the wood fence not being maintained, which provides no barrier around the pool and is a life safety issue to the public by the time specified. The city would like to give the respondent until March the 2nd, 2023 to correct the violation or pay a fine in the amount of $100 a day until compliance is met. The city would also request that the cost incurred in bringing the case before the magistrate in the amount of $236.78 be paid within 7 days of the written order of the special magistrate. And that concludes my presentation.
I know you said it as part of your recommendation. I just want to make the record, want you to make the record with this is testimony. Is it your opinion as community compliance officer that the condition of that fence represents an immediate threat to life, safety, and welfare?
True.
Based on the evidence testimony presented, I will find in favor of the city, find that the respondent is in violation as stated in the notice of violation and as testified here to today. Find that the respondent did At the 11th hour, cure the violation related to the vehicle. All the other violations remain outstanding. I will order the respondent to cure the remaining violations by March 2nd, 2023. I'm going to make one change to the requested order. For all of the violations except for the fence, I will find if they do not come into compliance for any of those, it will be a $100 per day fine. But if they fail to comply with the fence violation, I'm going to up that to $250 per day.
That's the only one they have left, is just the fence.
Everything else has been done except for the
Yes,
fence. I
yeah, he let
misunderstood
me
that.
in the backyard,
Oh,
and the pool water is clear,
Okay,
and
so
the
then-
vehicle was being towed away. So the only violation I have is the fence now.
Okay, then I misunderstood that. Then that makes it easier on me. I'm going to up that daily fine amount to $250 per day if they don't fix the fence.
Okay, thank you,
Do they
sir.
need a permit to fix that fence?
No,
Okay. As long as they're not taking it down and putting a new one up, as long as they're just replacing. the
right.
area.
I mean, when I grabbed it, it was just, I mean, I could wobble it. So I explained to him exactly what he needed to do to come into compliance.
And I will also put language in the order that authorizes the city to present to city council. If they do not comply with my order, the city is authorized to present to city council the life safety issue for the council to consider whether or not to use self-help.
Okay, thank you, sir.
Case number 2022-1994, Rosemary Matute, owner, location of violation, 4721 Pine Lake Drive, St. Cloud, Florida.
Good afternoon, Pam Neal, City of St. Cloud Community Compliance Officer. I am presenting this case for the property located at 4721 Pine Lake Drive. At this time, I would like to enter into evidence the following items: copy of the courtesy notice, copy of the notice violation, copy of the notice violation sent by certified mail, copy of the statement of violation, notice of hearing sent by certified mail, a copy of the PowerPoint presentation, evidence of mailings, a copy of the deed to the property, copy of the code sections in violation, copy of the costs incurred if the magistrate finds a respondent in violation in the amount of $188.70. The respondent is not here.
Thank you.
On November 28th, 2022, while on routine patrol, I noticed that a new fence was installed at this location without obtaining a permit. On November 29th, a courtesy notice was sent to the owner. On December 9th, the reinspection was performed, and a fence permit was not applied for. On December 12th, a notice violation was sent to the owner. On December 27th, I checked, and there was still no permit applied for. I took 2 photos. On December 28th, a notice violation was sent by certified mail to the owner. On January 13th, I checked the records, and a permit was still not applied for. I took 1 photo. On January 17th, a statement of violation notice of hearing was sent by certified mail to the owner. On January 27th, I checked, and there was still no permit applied for, and I hadn't heard anything from the owners. On February 14th, I checked, the permit was applied for on January 30th, and it was approved on February 13th. The owner called me and stated she would have the permit obtained before the meeting. I checked right before the meeting today, and the permit had not been obtained. It is the city's recommendation that the respondent be found in violation of allowing a fence to be installed without obtaining a permit at this location, and to have the permit obtained by February 28th, 2023, or pay a fine of $100 a day until compliance is met. The city would like to also recover the costs incurred in bringing this case before the special magistrate in the amount of $188.70 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Based on the evidence and testimony presented, I'll find in favor of the city, find that the respondent is in violation for construction of a fence without proper permits, find that the respondent has applied for and the permit has been approved and just needs to be picked up. Just to be consistent with my prior order on the above-ground pool, I'm going to give them until March 2nd. Just because very similar facts, I'm going to be consistent between those two. Also makes my life easier in drafting the order. So I'll give them until March 2nd to do that. If they don't comply by March 2nd, they'll fine of $100 per day until compliance is met. And we'll also order the respondent to pay the administrative costs in the amount of $188.70, which will be due 7 days from the date of the written order.
Thank you.
Status hearing, case number 2022-1719, Neptune Road LLC owner, location of violation, vacant commercial parcel, St. Cloud, Florida.
I'm going to go ahead and no-pros this case. They've come into compliance. There were some issues with the dedication of the right-of-way, so
But it's now in compliance.
it's now in compliance. Yes, sir.
Reduction of lien over 50,000, case number 2013-1943, Anatoly Oschak and Celia Oschak, owner, location of violation, 822 Ferris Court, St. Cloud, Florida.
Good afternoon, Your Honor. Jack Morrison for the city. This is a request for reduction settlement entered into between the respondents, Osadchuk and city manager. City manager signed off on February the 8th, the agreement. The total fines accrued of $149,600. This dates back to a case from 2014. Compliance was achieved 2018. Fines accrued of $149,600. And so the respondents have proposed to settle out by paying $20,000 total, payable in 4 monthly payments of $5,000 each pertaining to the accrued fines in the case, subject to your recommendation for approval and city council's approval within that time.
Okay. And based on what's been presented, I will recommend approval of that. And just as it's stated in the agreement, that it's that a recommendation for approval would, or my recommendation would be that if they miss any of those monthly installments, the fines immediately revert back.
Yes, sir. Thank you.
Motion for authorization to foreclose, case number 2022-210, South Florida Barbecue of St. Cloud, Inc., owner, location of violation, 4475 13th Street, St. Cloud, Florida.
Yes, Jack Morrison for the city. This is on that motion for authorization to foreclose on this code enforcement lien case was last year, and relating to violations which were determined in April's hearing. Correction date was May 3rd of last year, or a $100 a day fine. As of the date of the motion, which was February the 3rd, the noncompliance accrued fine and lien was $27,600, and along with unpaid costs of $254.16. So the order was recorded back in 2022, June, I believe. So it's been more than 90 days. City is seeking an authorization for foreclosure, and in the event you're inclined to grant that motion, I have a proposed order which may be in your packet, but if you don't, I've got mine. Okay.
You've checked every box that has to be checked for authorization to foreclose, so I have no reason to say no.
Okay.
And I will enter the order that's been presented to me.
Thank you, sir. That is all.
Yeah.
Yes, I'm sorry.
That order is signed.
New business, none. Next scheduled meeting, March 15, 2023.
Anything else from city?
No, sir.
Thank you all. Adjourned.
I do have a question.